How to become a POPI compliant creative business by the 1st of July 2021. Today we are going to be discussing the POPI Act. POPI in short refers to the protection of personal information. Every business must be compliant by the 1st of July 2021. That means that the POPI Act is applicable to you. Now let's start off about what is personal information. The Act defines two categories: special personal information and general personal information. General personal information refers to contact numbers, emails, and so on. Special personal information refers to religious beliefs, biometric information, health status, health history, and so on. The main thing about information in a business situation is that information has a cycle. That means you collect information, you use that information, you store that information, perhaps you share it, you market to it, and then you archive or delete it. That means that information in your business has a whole cycle that it goes through when you use that information. The POPI Act is not about you not being allowed to use information to market or make money. It is about us as South Africans respecting information and not abusing it. It is about you and your business following processing conditions and standards in which you are processing information in your business of your clients and your prospective clients. And likewise, it's about other businesses respecting your private information and your personal information and not abusing it. Similarly, that of our children, which is also very important, that companies are protecting and not abusing personal information. So when you consider becoming compliant, think of the broader spectrum about why we want to ensure that information is being respected in South Africa. The Act stipulates that information must be processed according to certain conditions. The conditions, in short, refer to accountability, lawfulness referring to the client giving consent to you using the information, and that there being a lawful reason why you have that information. Then restricting further processing of information, meaning that you can only use information for the duration to which your client has consented to. Limiting the purpose for which you are using that information, meaning that information that you have received from your client and to which they have given you consent to use, you can only use that information for the purpose to which they have consented to. A good example is that you cannot get information from clients on your one business to receive newsletters, and now you have a new startup and you want to use that information that you have gathered from them in order to market another business, services, or products. You must be very specific about the purpose for which you are using your information. Next, openness. Openness refers to transparency. Clients and customers must be allowed access to the information which you have of them. They must be able to change, amend it, and also request that you delete that information. It is just all about us being transparent in South Africa about the information that we have and that what we use. Quality. Information that you receive must be of a good quality. That, in short, refers to you should have received it from the client directly. It is best case scenario that you have received it from the client and they communicate to you what information they would like you to use. Last one is security. Security is a very important processing condition. That refers to information that we have on each and every device and that it must be secured. Your IT software must be up to date, your devices must be secured, Wi-Fi must be secured, and if you are carrying around hard copy information with you, then you must also be protecting that personal information. How to become compliant by the 1st of July 2021. This is going to be an easy, practical guide to show you that you can become compliant by the 1st of July and join the rest of the businesses of South Africa to respect the information that we have of our clients. Step number 1 is to do a gap analysis. Gap analysis refers to you analyzing exactly what is happening in your business, what information you have, where are you getting it from, how are you storing it, how are you securing it, and at which point and how are you deleting that information. That is basically you understanding exactly each and every aspect of the personal information cycle in your business. Then the next step is to ensure that you are going to spring clean the information that you have. Remember, when we went through the processing conditions, I referred to lawfulness, accountability, and restricting further processing and limiting the purpose for which you are using it. That means that you need to make sure that all the information that you have at hand, that your client had given consent to you using it, that you are allowed to use it, and that you are limiting the purpose to which you are using it for and for the duration which you are using it. So you need to go through all of your information that you have available of your clients and contacts, and you need to delete all of the information that you are not allowed to use, that your client didn't give consent to, or that they've just unsubscribed, or maybe they are old clients, or maybe you don't need their information anymore for marketing purposes. Information doesn't just refer to clients, but it also refers to our staff. So if you have existing information about previous employees or anything to that extent, make sure that you have consent to use them, store them, and secure them. So now you have analyzed the process cycle of information in your company, and you have spring cleaned all of the information that you have and have ensured that all of the information that you currently have has been consented to and is relevant for what you are busy with now. The third step is then to implement business policies and procedures. So this step is going to take a bit of work. Firstly, get a privacy policy. Each and every company must have a privacy policy. Your privacy policy would typically be a document that sets out how your business processes information, how you're collecting it, securing it, storing it, deleting it, sharing it, but also what your client can do in order to safeguard information. How are they consenting to you using information, and how can they request you to delete their information? So those are the basic things that go into your privacy policy, and you can make that privacy policy available on your website. Next up, very important, is consent. If you think of POPI, you need to remember consent is key. That means that your client needs to consent to you using their information. The best practice is to implement consent into each and every document that you have. What do I mean when I say that? Implement a consent into all your contracts that you are using with a client. Your consents need to refer to what they are consenting to, how you are going to be using that information, and for how long you are going to be using it, and in which format they would like to receive that information. All my contracts on the legal stuff have been updated to include a clause where your client can consent to marketing. It allows for the correct processing conditions and for your client to be able to tick what format of marketing they would like or dislike. A big change with the new POPI legislation is that your client must opt in if they want to receive direct marketing. That means that you only have one chance in order to contact a brand new client and ask them whether they would like to receive information from you and direct marketing. If the answer is no, then you have no chance ever again, and you need to delete that information that you have of them. There are specific forms that they prescribe that your client needs to complete in order to consent to marketing, and I'm going to make those forms available to you in a format that is relevant to creative businesses. So make sure that you watch out for my posts in the next week to come. Next up, implement an internal policy into your business. That is you making sure that you know how you are going to be collecting information, sharing it, storing it, and deleting it. This policy must be compliant with the Act, and you must know exactly how, when, and where you are going to be using information. Remember, the golden rule is consent is key. So each and every piece of information that you have, you must have had consent to use that information for the purpose which you want to use it for. Implement a cookie policy on your website. The regulator still needs to decide on implementation of cookie policies in South Africa. But because of the current status, my suggestion would be that you do implement a cookie policy on your website so that your clients can consent to you being able to use that information. Better safe than sorry when it comes to protection of personal information. Next up, GDPR. If you are selling to European customers or clients, then you must comply with GDPR, and that is basically the European standards for processing personal information, and it's very much in line with the Protection of Personal Information Act of South Africa. So if you are selling to overseas clients, then ensure that you are complying with the GDPR as well, and that you're incorporating those terms into your privacy policy that you're making available on your website. So by now, you would have analyzed your business to understand exactly when you are collecting information, sharing it, and securing that information, and ultimately destroying it. You would have had a cleanup of your business of all existing data that you have available, and you would have implemented policies and procedures to ensure that you are complying with the processing conditions of the POPI Act. Lastly, you must educate your staff. It's very important that if you do have employees, that they must be educated about personal information, and you should keep record of the fact that you have attended training sessions and that your staff has attended training sessions about exactly what your privacy policy has stated about using personal information in your business. Let's talk about the information officer. The head of a business is automatically appointed as the information officer. A head of a company can delegate the duties of an information officer, but if not, that person will remain responsible for ensuring that your company is complying with protection of personal information. So make sure that whoever is the information officer, that they understand that they must ensure that the business is complying. Now, why am I saying that the information officer must make sure that the business is compliant by the 1st of July 2021? Well, the reason is there's some hefty fines involved. 1 to 10 million rand for any non-compliance, and your customer can put in a claim of damages against you if you have breached the conditions and you have leaked perhaps information of them, and as a result they have suffered damages. So as you can see, it is quite extreme that you ensure that your business is compliant by the 1st of July. Let's recap today's session. We started off by going through the definitions of personal information, and consider that you are processing information. The Act says you need to process it according to certain processing conditions, which included accountability, lawfulness, restricting further processing, limiting the purpose for which you are using it, security, openness, and transparency. And then we had a look at the different steps that you are going to follow in order to get compliant. The first one was to analyze the information gaps in your business. Number 2 is to spring clean all of the information in your business. And number 3 is to implement policies and procedures. The policies and procedures included a privacy policy on your website, a website cookie policy, a GDPR policy, an internal privacy policy, and including consents into your contracts, as well as direct marketing consents to new customers. Lastly, we had a look at the fact that you need to educate your staff and ensure that everyone is familiar with POPI and the implication in your business. So that concludes our POPI session for creative businesses. If you follow my 4 steps, you will be compliant for the 1st of July 2021. But be sure to follow me throughout the next week, where I will be sharing tips on how to become compliant and also freebies that you can use to implement in your business and make sure that you are compliant by the 1st of July 2021. Also remember to leave a comment if you found this helpful and tag a South African business friend to make sure that we all as South African businesses are compliant by the 1st of July 2021.